Lords, my lady, appear together with my learned friend Srivan Devi for the appellant, and my learned friends Hervé Duval, senior counsel, and Nicolas Henry appear for the respondent. Lords, it is the respondent's contention, when we look at the plaintiff's summons, that it was on the 15th of March 2013, he was terminated, his services were terminated, and it is contrary to the appellant's contention today, and as such, according to him, he was wrongfully dismissed. In cross-examination, the respondent twice confirmed that his cause of action was solely based on Section 38(2)(a) Roman 3 of the Employment Rights Act. I'll come to the Act later on, Lords, but it is to be found at page 693 of the brief. I'll come to that at a later stage of my submission. So on these two occasions, if I want to be precise, it is to be found at page 478 of the brief, at line 15, where in cross I did put the question. Third line, Mr. Souzier, your plaint, as you have
said... I'm so sorry.
I'm sorry.
Can you just allow me to catch up with you? I just need to...
I'm sorry, my lord.
Yes, yeah, I'm sorry.
It's 478.
Surely what a person's case is not determined by answers in cross-examination. It's a legal question.
Certainly.
All you can cross-examine about are the facts.
Certainly. But
it's an improper question to try and get people to agree that their case is this or that, which
all right.
One encounters from time to time.
I'll accept that, my lord, certainly. The learned magistrate, in his judgment, the judgment of the learned magistrate is to be found at pages 231 and 241.
I'm sorry, it's me being slow again. Can I just at least mark the passage that you were drawing our attention to?
It is at page 478, my lord.
Yes, and where on the...
Line 15.
At line 15.
All right, thank you.
16,
Your plaint is essentially based under, he said, hum.
Yes, the first answer.
And then he's forced to answer.
And then he says,
yes.
are we agreed?
Right, okay. Yes, thank you.
My lord, just to pick up your point, in fact, this question was put following the facts as highlighted in the plaintiff's summons, because in the plaintiff's summons it is clear that Section 38(2)(a) Roman 3 of the Act is mentioned. So,
and sorry, do you have the bundle reference for the summons?
For the plaintiff's summons, my lord, it is to be found at page 5. And your lordship will see that at page 8, paragraph 18 of the plaint.
Right.
So, the judgment of the learned magistrate, he made, I humbly submit, a detailed analysis of the facts, which is even acknowledged by the Court of Appeal, and he came to one conclusion at page 240, bottom of page 240. If I may read, the last line, the defendant was therefore entitled, the defendant being the appellant today, was therefore entitled to find that the charges laid against him in document K1, dated the 6th of June 2013, have been established, and that such acts do constitute acts of gross misconduct. I find that the defendant has established the termination of the plaintiff's employment was justified in the circumstances, and that it could not, in good faith, take any other course of action than to terminate the plaintiff's employment for the reasons given in document B, which I'll come to that. It is the letter of dismissal.
And document K1, that is the letter setting out the charges against.
Yes, my lord. Melody.
And bundle reference for that, if you could.
The document K1 is to be found at page 258
Thank you.
and 259.
Thank you.
Subsequent to that judgment, the respondent appealed before the Supreme Court, and your lordships will see that there are 8 grounds of appeal before the Supreme Court at pages 298 and 299. Although my learned friend appearing for the plaintiff then was minded to canvass all the issues before the Supreme Court distinctively, the learned judges disposed of the appeal considering 2 grounds, 2 and 4, and they are reproduced in the Court of Appeal judgment at page 416. My lords, before going onto these 2 grounds, I would like to go to the written submission, the written case of the appellants at page 645 of the brief, paragraph 7, where reference is made to the following. I'll just read part of it. Paragraph 7. It is settled law that a decision of the industrial court may only be reversed if it is found that the industrial court misdirected itself or made findings of fact that are, I would say, perverse, not preserve. In the judgment of SMEG, there are 2 judgments which are referred to. I won't go through what is said in the case of SMEG and the case of Montrésor and Montdésert against the Ministry of Housing and Lands. These 2 judgments are at page, one of them, SMEG, it's at page 783, paragraph 19, this passage, and the passage which is highlighted in the case of Montrésor and Montdésert is at paragraph 2, page 754. Lords, according to the judges hearing the case on appeal, the crucial aspect of the case was the conversation that the respondent had with one Mr. Rivette on the 15th of March 2013. This is highlighted at page 413 in the judgment of the learned judges. It is at line 19 and 20, page 413. The learned judge, the learned magistrate, did pronounce himself on that specific issue, and this is to be found at page 236, line 32, where the learned judge says, 5 lines from the bottom, therefore it was inappropriate for the plaintiff to consider that he was dismissed from his employment as from the 15th of March, when he was told by Mr. Rivette that he had no longer his place in the firm. En passant, if I may say, the learned judges before the Court of Appeal appreciation of Mr. Montocchio, because you will see that there are two persons that the respondent is going to meet on the 15th of March, one of them being Mr. Rivette, the other one is Mr. Montocchio. The learned judge's appreciation of late, because he passed away in the meantime, Mr. Montocchio's role, I think, was incorrect, because according to them, Mr. Montocchio was the group human resources, which he was not, and this is to be found at page 413 of the brief, 413. You will see at page 3 lines from the bottom, the then group human resources. In so many words, he was a person in authority, which I will say he was not. At page 414, your lordships will see at line 2 and 3 that Mr. Montocchio had authority on the issue of the appellant's employment, which I humbly submit he had no authority, because at page 532, and this is accepted by the learned magistrate, because at page 532, your lordships will see that when the representative of the appellant company was cross-examined by my learned friend, top of the page, your lordships will see, I think he was, in fact, in examination in chief. I was putting questions. Your lordships will see that top of the page, he clarifies the fact that...
Which top of which page?
The page 532 of the brief, Melanie. Top of the page.
And Francis is Monsieur
Montocchio. Yes, yes. So he was the secretary of the company, and he was in charge of pension fund.
And sorry, who's being examined in chief here?
The representative of the appellate company, my lord, Mr. Bertrand Piat. I don't think it is very important, but I think that the judges got it wrong, because at page 415, they will say in their judgment, it is to be found at page 415, third line from the top. This was followed by a letter dated the 30th of May, signed by Mr. Piat, the Group Human Resources Advisor, who had by this time taken over from Mr. Montocchio. This is not correct. He had taken over in 2009. I don't think it was, but I don't think it is that important, because it is a factual issue which was determined by the learned magistrate. So if
the magistrate got that wrong, did he?
No. The
Okay.
magistrate did not get it.
Well, he described Mr. Montocchio as the group HR consultant.
Yes.
And you just said he was the company secretary and in charge of pensions.
Yes, but what I'm saying is that the learned judges in their judgment will say that his job was taken over by Mr. Piat, which is not correct, because obviously in 2009 Mr. Piat was already in the shoes of Mr. Montocchio, but this was determined. I don't think it is an important issue at the end of the day. So if I may go to the main issues, that is grounds 2 and 4, that is the grounds of appeal before the board today, my lords, is to be found, the grounds are to be found at pages 616 and 617 of the brief, and your lordships will say that there are 4 grounds of appeal. The main issue is the state of pleadings.
The what?
The state of pleadings. This is what the learned judges say in their judgment. And I think that my friend will probably go through the plea, that is the defense, which was filed on behalf of the appellant. It is at pages 15 to 20, my lords. This is the plea of the defendant, now the appellant. And the critical part of it is paragraph 16 at page 19. Now, of course, as I said earlier on, the main issues were the 15th of March, the landmark of it, 2013, this time, this specific date, leading to the disciplinary committee in July, that is March to July. A major part of the respondents' cross-examination was dedicated to two issues: date of dismissal, that is whether it was the 15th of March or the 5th of July, and secondly, wrongdoings. Were there any wrongdoings on the part of the respondent? This is where I will humbly submit that the learned judges got it wrong at the end of the day. It is undisputed that the audit spanned over a certain period of time, that is from January, the 31st of January, when document C was...
Of which year?
2013, milady. The whole events will be in 2013. That is on the 31st of January 2013, where the respondent was given one document, which is document C, and document C is at page 246 of the brief. Up to the 10th of May 2013, where he was given document G, which is at pages 250 and 251. Now, my lords, in cross-examination, the respondent readily admitted that the audit was not over on the 31st of January 2013. If we go to
are you going to deal with the pleading at some point? Because
yes, of course. It is.
I was unable to find in the defence any allegation of misconduct.
This is the point. This will be the point.
Well,
was it necessary to have the word misconduct or not in the plea? That would be, in fact, I think.
Well, is it necessary? Was it necessary for the defendant to establish misconduct in order to justify not paying severance, or not? Well, it would be helpful to understand what the law is.
I will say that what is written in the plea was more than sufficient, coupled with the findings of the learned magistrate.
Sorry, you accept, do you, that the defendant did need to establish misconduct in order to justify not paying severance?
He had to
as a matter of law?
Of course, he had to satisfy the learned magistrate that the decision, that is the defendant, had to satisfy that the decision taken to terminate the employment was taken on sound premises. That is, that there was a misconduct. Of course.
And where in the pleading is it alleged that there was misconduct?
I was coming to that later on, that if your lordship wishes me to deal with
No,
it.
sorry, just because you asked us to turn up the pleading, so I thought you were going to
Yes, I will,
make
certainly.
some points about it, but if you want us to turn away, that's fine.
No, I will certainly come. I think it is the main point.
Right.
And I
Do
think
you
that
accept that there needed to be somewhere a finding that he was guilty of this misconduct
Yes.
in order to justify not paying him severance?
yes, we have to satisfy, the defendant had to satisfy that he could not take any other course of action. And my submission will be, when we look at the law, it is obvious that it encompasses the issue of misconduct. And the judgment of the learned judge, I referred to one passage earlier on, he makes reference to a specific document, and he analyzes all the issues which were put to the defendant then, to the plaintiff then, I'm sorry, to the appellant. So I will, unless your lordships wish me to deal with that point straight away, but I do think that it is obvious from the cross-examination of the respondent that the audit was not over on the 31st of January, because he said so at the beginning of his case. He said, what I had to say, I said on the 31st of January, and there was no other issue as from that date. This was in chief, and it is to be found at page 440 of the brief. But if you want me to just go to 440, it was top of the page, the first 4 lines.
So he's saying the things they wanted to be discussed were already before the court since January. I didn't think there were any court proceedings in January, were there?
No.
So can you just help us to understand what it is that you're asking us to look at?
I would say company.
En cours. Qui avait déjà commencé. En cours.
Ah, yes, yes, yes.
En français.
Yes, yes. It was en cours, not in court.
In court.
It was in the
I see.
process.
So this is a mistranscription.
Yes, probably, yes. Yes, I've worked on the English version. I don't know whether my friend has done the
Yes,
French
I
one.
was
Yes,
wondering.
it's en cours.
It's obvious Michel Lafresière is a
C-O-U-R-S.
French speaker.
He's a French speaker.
Is this actually a transcript, or is this a translation of a transcript?
It is a translation.
Yeah, I now see at the top of the page. I hadn't picked that up before.
Yes,
Do we actually have the French transcript?
yes, it is in the first. Yes, it is. It is at pages. From pages 21. I must say that I did not cross-check. I went straight to the English translation, not to... Yes, but my friend is totally right. He's perfectly right.
C'est clarifié à un moment donné.
Page 25. Yes, but then there is, if we look at page 25, there is a misspelling because en cours, C-O-U-R means court. But it should have been en cours, S, with an S. Yes.
I don't want to take you out of your order, but it might help if I were to tell you what our attention has been focused on.
Certainly.
It seems to us that the appeal court proceeded on the basis that the present appellant, the employer, had to prove to the tribunal, the magistrate, that there had in fact been gross misconduct on the part of the employee.
Yes.
And they found that there was, well, they found in the first place that hadn't even been the pleaded case of the employer, and that the magistrate that it had not been proved in front of the magistrate, and he'd made no finding to that effect. So that seems to be the crucial issue seems to be whether they were correct in taking the view that had to be proved before the magistrate in the first place, and that it hadn't been in the second place.
All right.
Or at least that there had not been a reasoned judgment
Yes.
explaining why
Yes.
those findings had been.
Yes. So let me deal with that point.
And having reached that stage, they then decided to reach their own decision on the matter, which was that the employee was entitled to the statutory severance pay.
Right. So I'll go straight to that point. I think it's in order to enlighten. My submission to your lordships is that the learned magistrate went through all the facts. That is, what was put to the respondent, and your lordships will see, in fact, the judgment goes over 10 pages only. If we go through the judgment at page 231, the first page.
Sorry, just before we launch into this, how does that help matters? If it hasn't been pleaded, I mean, surely the respondent is entitled to come to court to meet the case that's been pleaded against him.
Yes.
I mean, even if matters are raised in the course of
Yes.
The trial, if it hasn't been pleaded and he hasn't been put on proper notice of the case he has to meet, there may have been other things that he would bring forward to
Right.
To meet such a case if it had been pleaded.
So what if no objections?
Let us go to the plea. Let us go to the plea. What was pleaded? Let us go to the plea straight. So it is at page 19, paragraph 16, that is line 4. The defendant denies paragraph 19 and 20 of the précipé, more specifically that it has wrongfully and unjustifiably terminated the plaintiff's employment, and further avers that, 1, the plaintiff failed to attend the disciplinary hearing and accordingly to submit himself to disciplinary proceedings. Secondly, this is the important part, it could not, in all good faith, have taken any other course but to dispense with the plaintiff's services. Now, my lords, if we go to what the law says.
If I could just make an observation, there's no averment of why they could not in all good faith have taken any other course. I mean, was it because he failed to attend a disciplinary tribunal? Was it because he had taken another job? Was it because he was guilty of gross misconduct in relation to the plants, the flooring, and so forth? I mean, it's not clear from the pleading.
I can understand your lordship's point.
You would have thought that if you're going to allege gross misconduct, there has to be something saying that in the pleading.
Yes.
You can't just infer it from kind of reading between the lines. And I can't see anything in the pleading that says he was guilty of gross misconduct, let alone specifies what that misconduct was.
Yes.
I mean, if anything, sorry, just so that you could deal with all these things at the same time, if anything, the focus seems to be on the failure to attend a disciplinary meeting, which in itself is misconduct, if you've been given a lawful instruction to attend.
Yes, but when we, my lords, if my understanding of it, my explanation, let us say so, is that when you look at the law, the existing law, because it has evolved since, we are dealing with the Employment Rights Act, and Section 38 is the focal section. It is at page 692 and 693 of the brief. And Section 38 2 at page 693. No employer shall terminate a worker's agreement, A, for reasons related to the worker's misconduct, unless, 1, he cannot in good faith take any other course of action. This was what was pleaded by the defendant, the appellant then. And secondly, the worker has been afforded an opportunity. This is not disputed. But in fact, what the defendant did, that is the appellant, is that it stated that they could not in good faith take any other course of action. This is what the law says. And it is related, when we look at paragraph 2A, to the worker's misconduct. Now, was there in the mind. Okay, it was not specifically pleaded, of course, I do accept. We read the plea, and it is obvious that what is written in paragraph 16.2, it could not, in all good faith, have taken any other course of action. But we say that this averment is in direct relation with paragraph 38, which says it must be related to misconduct. So was there a necessity for the defendant then to go further than that? Was any person involved in the trial perturbed or affected in their mind as to what was there to meet? And if we go through the whole trial, my learned friend, when he was, I'll just go through a number of phases in the course of the hearing where I will suggest to the board that my learned friend, the learned magistrates and the learned judges, the learned magistrate and the learned judges, there was no misapprehension whatsoever. They all had one.
It's very surprising that the Court of Appeal didn't say something like, well, everybody who works in this area knows that if you say in your judgment that there was no, they couldn't in good faith take any other course, everybody knows that that means that there must have been a finding of misconduct. But the Court of Appeal didn't say that. They didn't.
They have made allusion, my lady. I will come.
This section you've shown us is a procedural protection, but
yes.
it's additional to, isn't it, the basic requirement, which is to prove that the termination was justified on grounds of misconduct, the substantive requirement.
Meaning that...
that was my reading of the, maybe coming to the decision of the board, which the Court of Appeal, which the Supreme Court,
yes,
in their judgment.
My Lord, the whole issue will be, did we have to have the word misconduct in there if we had replicated what the law provides, that is section 38. Was, as I said just now, was any person under any misapprehension? And I will go through a few of the instances where I will humbly submit that neither my friend, nor the magistrate, nor the learned judges were under any misapprehension as what was the real issue before them. If I go to page 194 of the brief.
Just before, I'm sorry, just before we leave this, the employee's case, I mean, the employer has to comply with all the requirements in 2A. These are cumulative, aren't they?
Yes.
And his case, as I understand it, was that there had been a failure to comply with the procedural requirement in Roman 3.
Yes. This has been decided by the magistrate, of course. He made an analysis. This is why I started with the audit. I wanted to bring your lordships to the point where on the 10th of May, that is document G being produced, that he signed this document, and that it was on the 28th, it was on the 10th of May, that on the 28th of May, this document was submitted to the company, which then brought it before the Corporate Governance Committee. It is document V, if I'm not mistaken. And it was decided on that day to have a letter, document H, sent to all 4 employees, main employees.
Yes. Sorry.
Well, I was just going to say, I think we may have been a bit too quick in saying that the requirements here are procedural. 2, 3, 4, and 5 are all procedural, but,
yes.
But 1 seems to, it's obviously not a procedural requirement. Are we to understand that that's a substantive test?
Yes. Yes, I agree, my lord.
Does that requirement subsume the requirement of proof of misconduct?
I would think.
I'm sorry, I missed your answer.
Yes.
Yes. Okay.
I was, if I may, my lords, I was going to embark on the issue of all the
this is crucial, so it is. Be quite clear about it. So by offering to prove that one was met, that one was satisfied, which is what you offered to prove in your pleadings,
Yes.
we're to understand, are we, that that is an offer to prove that the dismissal for misconduct was substantively justified.
Yes, and I will conclude at the end of my submission by saying that it was exactly the frame of mind of the learned judge when he delivered judgment. I think that there was absolutely no doubt in his mind that the issue was misconduct leading to the cannot in good faith take any other course of action. And he says it clearly. I'll come to that.
So there is not somewhere else in the law a requirement to prove
No.
misconduct, gross or otherwise. This is what has to be proved.
Yes.
All
Yes,
right.
my lord. Now, I was...
I'm so sorry, just to take up a bit of time on that. How does one know what the basis of misconduct there is for the averment in one? You can't, in good
Yes.
faith, take any other course of action. Take this case. You've got two things, arguably, that the employee has done wrong. The underlying complaints of misconduct, but also he's failed to respond to a lawful order to turn up to the disciplinary hearing. If you just prove a conduct in good faith, take any other course of action, which of those two is the underlying predicate for that averment?
I would say both, my lord. I would say both because in this
Or
case...
either.
I'm sorry, my lord?
Both or either.
Either would do, but in our case, I'm saying, of this case, I think that both. Because it is undisputed that all these issues, that is, I won't go through it, the personnel employed at third parties, the wooden planks, the gate pass, the car gate, all these issues have been specifically put to the plaintiff, to the respondent now. And all these issues have been analyzed by the learned magistrate. And he has come to the conclusion at page 240.
But which of them, where does it say in the judgment, which of them he found was proved? He might have decided that some of the plants had not, or that
No.
some of the things in document K1
Yes.
hadn't been proved to the requisite.
No, what he says, my lady, is at the end of the judgment, I just went through this passage earlier on, the defendant was therefore, he made an analysis of all the facts. And then he said, the defendant was therefore entitled to find that the charges laid against him have been established and that such acts do constitute acts of gross misconduct. I don't think, with due respect, my lady, that it was incumbent on the learned magistrate to say, this is proved, this is proved, this is proved, this is proved. In fact, the defendant admitted most of the issues. All these were admitted. There was no...
As I understood it, one of the points taken by this employee was that the decision had been taken at an earlier stage.
Yes.
In other words, that was at this point that the issue that he was putting forward as absolving him, that it was a charade, a hearing that he was going to be subjected to, and consequently he wouldn't attend it.
This was, in fact, the first question which was put to me.
Yes,
In fact,
he was arguing, as I understand it, that there was a procedural flaw in his dismissal because he had not been given timeless notice of the charges. Yeah.
I started my submission, my lord, by saying that the main issue was whether the date of dismissal was on the 15th of March, that is according to the plaintiff then, or on the 5th of July. So
I wonder if it's worth just going back just for 5 minutes to identify the main steps in the chronology and the issues at the points that were taken by the employee at different stages. Because the case does seem to have developed a little bit, but certainly, for my part, I hadn't understood
all right.
from the defendant's case, from the employee's case, from the employee's case, it to be an issue as to whether or not the acts of which he was accused had been committed.
Had been committed.
Committed, whether they had been, whether he had done them or not.
Yes.
The matter was rather whether
All
or
right.
not...
Would your lordship, is there an issue about the dates, that is the 15th of March and the 5th of July? Would your lordship wish me to go through that, whether the learned magistrate was right to find that the date of dismissal was on the 5th of July, not on the 15th of March, and that, as such, the procedural issue was no longer a valid point. Because if your lordships were to come to the conclusion that he was dismissed in his mind on the 15th of March, then we are in breach of section 38 2A3. This is not what the learned magistrate found, and this is what I'm ready to submit if your lordships wish me to go through this sequence of events and the way, his cross-examination, what he said in court, and the ultimate signature of document G on the 10th of May.
Well, I think...
Well, you've got a finding by the magistrate which hasn't been, it's not an issue before us.
It is factual.
Yes.
So
the question may be whether or not he ever had notice of the charges that were made against him. The charges, as I understand your case, were set out in the letter,
yes.
the 12th of April.
No, not 12th of April.
I beg your pardon, not the 30th
of May.
The 30th of May letter.
Yes.
Sets out the charges after the full audit.
Yes.
And then the question is whether or not he was ever given an opportunity to meet and to answer those charges, if that is what he wished to do.
Certainly, my lord. I'm quite prepared to go through that because your lordship will see that document, this is document H, in fact, the 30th of May.
H, please.
Yes, I'm coming to this page. At page 252 and 254. Chronology, we are on the 30th of May. And according to the evidence, if your lordships were to turn to document V, which is at page 272, your lordships will see that 272 to 274. This is the minutes of proceedings of the special meeting of the Corporate Governance Committee of Mauritius Hotels. It was held on the 29th of May. That is on the eve of document H being forwarded to the respondent. So, according to the appellant, on the 10th of May, document G, which is at page 250, 251, 10th of May, this is the end of the audit, acknowledged by the respondent, 10th of May. According to the auditor, the report was prepared. It is document Z, and it is to be found at page 286.
So, just so I can be clear, the document page 250 is drawn up by the auditors.
Signed by the respondent.
And given to the respondent at a meeting between him and the auditors, and they all sign.
Yes.
It seems. Right.
Yes. 10th of May.
Yes.
Then, on the 28th of May, according to the appellant, a report is deposited at their offices, and the report is document Z. It's page 286. 28th of May. On the 29th of May, that is the Corporate Governance Committee, 29th of May, page 272. On the 30th of May, a letter is sent to Mr. Lafresière, that is the respondent. The 30th. Document H, 252. He does not respond, and there is an exchange, as your lordships will see, of letters between parties, let us put it that way, attorneys and parties. And the proper charges are to be found in document K1, which is at pages 258 to 259, on the 6th of June. For reasons stated in the letters, that is, I want to be fair to the respondent. The respondent's stand has been expressed in the various exchanges between attorneys and with the responsible officers of the appellant. He does not attend on the 4th of July. And on the 5th of July, document B is sent, which is at page 245. Now, this document is of importance, obviously, because it was produced in court by the respondent that he was duty bound to produce, and you will see that this letter says you were duly convened to appear before a committee. You did not attend, did not provide any reason. The committee was held in your absence and has been concluded on the said date. This serves to further inform that management 1 has received the report of the chairperson, come to the conclusion that all the charges had been proved, has accepted the report, considers that your acts and doings are tantamount to gross misconduct, take the view that it cannot, having regard to the above, and in all good faith, take any other course of action, any course but to dispense with your services. So this is the document which gives the reasons, that is, no explanation, proved, gross misconduct, cannot in good faith. This is on the 5th of July.
So it wasn't for failure to turn up?
Yes?
It was for the misconduct which led to the hearing? Or did you say it's both?
My Lord, yes, I would say. Because if you are given the opportunity to come and give your explanations and you don't come, and the committee was held. It was not that the committee was just closed, it was held. And evidence was adduced, and the chairperson of the committee did provide a report, in which report she said that all the charges had been proved, and that I don't think she has to say that there was misconduct, proved or not proved. It is for the management, the employer, to say, in the circumstances, we think that it was a gross misconduct, and we have no other course of action but to terminate your employment. Mm-hmm. So I think that it is a chronological issue which cannot be faulted. I would say that it was crystal clear from the start what was at stake, what was the issue, and I wanted to embark earlier on whether any party had any misconception about what was there to meet reading the plea, because I can understand from your lordship that there was maybe a word which was not there, but we say that there was no need to have the word.
No, well, it may be that we've been proceeding on a misunderstanding. I mean, if what you're telling us is correct, the issue for the magistrate is whether it's been proved that the employer could not in good faith retain the employee in its employment.
My Lord, the judgment for me of the learned magistrate cannot be faulted, because he says at the end, was therefore entitled, page 240 and 241, I'm sorry to come back to that, but it is clear that he goes through all the facts, he goes through all the issues, and he says that, okay, that the charges laid in document K1 had been established, and that such do constitute act of misconduct. So, of gross misconduct, not misconduct, gross misconduct. So, I find that there was no ambiguity at all in the mind of all of us. And if I may, my Lord, just to close on this chapter, indicate to the board that the mindset of all of us, that is of my learned friend, of myself, of the magistrate and the court and the learned judges, were focused on the same issue, that is misconduct and good faith.
Well, if you look at page 463 in the judgment of the Court of Appeal of the Supreme Court.
463?
463.
Yes. Is it 417 in...
Yes, maybe it's 417.
417, yes.
It says there, learned counsel for the respondent, that must have been you, confirmed that no evidence was produced before the learned magistrate to substantiate the charges.
This is totally misconceived. I was going to say that it is totally misconceived because he was taken to task. He was cross-examined on
Well,
all...
he may have been cross-examined, but that's not necessarily evidence.
But
If just putting questions to him, but was there evidence put before the magistrate to substantiate the charges in
Yes.
document K?
if we continue that phrase, my lady, with due respect, however, it did put the charges to the appellant who accepted them.
Yes, well, the appellant says he never accepted them. So, but what apart, I mean, you couldn't have known when before you cross-examined him what he was going to say. So if he hadn't accepted them, was there any evidence before the magistrate from which he could find that the charges were established?
I would have said, my lady, that if I put something to a witness and he accepts what I'm saying, I don't think the magistrate would be wrong if he says the charges, in fact, he has accepted them.
All right, but what's the answer to my question, though? If he had you come to court, to the magistrate's court, prepared to prove the misconduct that was set out in document K?
Yes. If he had not accepted the charges as put to him, it would have been my duty to come before the court and say this is what he did. I would have called witnesses, but if somebody is a plaintiff and he accepts having been party of some wrongdoing, I would waste the time of the court. It is my humble submission. I would waste the time of the court to enfoncer une porte ouverte, as we say in French. I would have said that it was not necessary. Yeah. And it is obvious that the learned magistrate came to a conclusion, factual conclusion, that the charges have been proved.
Yeah. Presumably he was the first person to give evidence.
Yes, yeah. He is the plaintiff, yes. Yes, yes. I was defendant, so...
Yeah. Yeah, so
as your lordships will see, yeah. I have called only 3 witnesses. That is the representative, the auditor, and Mr. Rivette, the famous interlocutor on the 15th of March.
Yes.
These are the only 3 persons.
So if he accepted the charges, it's scarcely surprising that no evidence was led after that.
Yes.
To substantiate them.
Can I just check, is there a process of disclosure in the courts in Mauritius? No, so you could, if he had denied the charges, you could just have produced documentary evidence at that stage, is that right?
Yes. Before this court, before the industrial court, there is no process of disclosure. Before the Supreme Court there is, but not before the industrial court. Lords,
would it be sufficient in an employment case to produce the findings of the audit committee, for example?
No.
You'd have to lead actual evidence, would you?
Yes. Yes. If there was no, if I was not satisfied, not me, but if the court, let's say, if when conducting the case, I was not satisfied that he had accepted anything, right, it would have been my duty to come forward and substantiate for the magistrate to be convinced or not that he had committed a misconduct.
Okay.
Lords, may I go to this point where everybody was on the same page.
Yes, I'm sorry if we've been rather delaying you in your submissions, but maybe that Mauritius lawyers have been take for granted points about the legislation here which weren't obvious to us. So we're grateful to you for the explanation.
Thank you, my lord. So at page 194 of the brief, when I'm saying that my learned friend, together with all of us, we were part of the same understanding, page 194, this is, in fact, my learned friend submitting to the magistrate that he wanted to reopen the case at a certain stage. You will see that at line 4, line 3, that is what he says. Now, the defendant, that is the respondent, does not dispute that there has been a dismissal, but according to the defendant, that is us, it did not take place on the 15th of March, but on the 5th of July, on the ground of misconduct and after due process was followed. This is my learned friend's explanation. The learned magistrate, at page 235, second paragraph, second line, in the judgment of the learned magistrate, the reasons for dismissal are at document B, which is the document I just read over, and the charges are in document K1, dated 6th of June. He added that as a plaintiff gave no explanation, he was summarily dismissed for misconduct. The learned judges, at page 415 of the brief, third paragraph, after the disciplinary committee was fixed for a hearing, the latter did not attend, and therefore, as a result, the charges were found proved, and he had no other option but to dismiss the appellant. I just read over earlier on 2 occasions, the final findings of the learned magistrate at page 240. But just to sum up on that, I will go to my learned friend's cross-examination, in fact, of my representative, that is the appellant's representative, at page 547 and 548. 547, last but one question put by my learned friend. Now you are aware of the reasons for which the company says, having dismissed Mr. Lafresière, it's document B. The reasons, document B, which obviously is gross misconduct. And I will end up by turning to page 548. Third question, put by my learned friend, I read. This is what he says. We fully agree that according to the company, it was because you were satisfied that the charges contained in the letter document K1 were proved, that you had no other choice than to dismiss Mr. Lafresière without any compensation, summary dismissal for gross misconduct. Is it your case? And Mr. Piat says, yes, this is our case. So, my humble submission, my lords, is that there was no ambiguity of whatever nature in the circumstances.
So you say this shows that everybody realised that the reason for the dismissal was the charges in document K and not simply his failure to attend the disciplinary hearing?
Certainly. And your leadership, I will add document K1 and document B. That is the letter of dismissal. If I may, just before concluding, my lords, read paragraph 17 of the appellant's written case. I think it it summarizes to a great extent most of my submission. It is at page 651. I'm sorry, my lady. This is what we wrote. 651, paragraph 17. Therefore, when an employer avers that he could not in good faith have taken any decision other than to summarily dismiss the employee, he must be taken to have averred that he takes the view that the employee's impugned acts and doings are sufficiently serious to amount to justified termination, the more so that there is no intermediate possibility of a normal rate, which has been discussed before, because in the case of Despéville and it was not in the case of Total and Abdourahman, at page 650, I was appealing in this case before the board, the issue of the ancient law, that is the Labor Act, was mentioned. The only requirement, my lords, was on the part of the employer was to comply with section 37 of the Act, subsection 2, at page 692, after the hearing. 692, top of the page, 37.2. The employer shall, at the time of notifying a worker of the termination of his employment, state the reason for such termination. And I will humbly submit that document B contains all the reasons which would justify a summary dismissal. If I may just touch ground 3, my lords, I have done with the 3 grounds, unless your lordships want any other.
Are you at some point going to take us to the points in the cross-examination of Mr. Lafresière in which you say he accepted that he had committed the acts, the misconduct set out in document K?
Yes, Milady, yes, it is to be, I can go through them, but it is obvious that even when my learned friend re-examines Mr. Lafresière, there is one issue, that is the wooden planks. Let us, out of wooden planks, he said that he was going to pay for it, and I did put the question, have you paid for it? And he said, no, I've not paid yet. And my learned friend in re-examination said, you have not paid? I did not think it was necessary because it would serve to no purpose. So, qui vole un œuf, vole un bœuf, in so many words. So it was one instance of one employee accepting that he had taken.
Well, I would welcome at some point being taken to the points, the passages that you rely on, not in the re-examination, but that you rely on in the cross-examination.
In cross-examination, yes, certainly, we can go through there. I will yes. At page 508 to 515, 515, questions are put at bottom of the page. Mr. Souzy, the time was 11 o'clock and ended at 11:15. It is not 15, it is 50, document G. And in all those pages, my lady, you will see that there are questions concerning the gate pass, no answers, at page 511. There are at least 3 instances where there is no answer. Mr. Grenouille, at a certain point, line 23, where he says that it is not correct to adopt such a practice, but it was common practice in the company. Mr. Adolphe, down the page, line 32, the wooden floorings, last paragraph. And if we turn to page 512, my lady, I did not take. My question, I don't know, it's not a question. Yes. He says, I was given. Who gave it to you? I was given. Were these items at the hotel? Yes. Are these items left with gate passers? He was in charge of the gate passers. I don't know. And then there are a series of no answers. Page 513. Therefore, you had already suggested to the auditors that you had repaid that sum in January when you first saw it for the first time. No answer. Had you said that you were agreeable to repay? No. And then you would say, middle of the page, had you repaid that sum? No. So it is an averment, an acknowledgement that you had taken certain things and that you are not repaid yet. Next page. It was common practice, line 13, but according to the books it was not correct. Do you agree? Yes. You had spoken about integrity, that's why I'm asking the question. Yes. Then, bottom of the page, line 32, I read one charge, no answer, concerning the billing of plants, 287,000 plants, or whatever. 27 plants. It goes up to page 515. Then, milady, there are questions at page 494 concerning the JCB, 494, JCB, as well as nursery plants, page 494, nursery. And these points, if I may say, are analyzed by the learned magistrate at pages 234 and 235 of the brief in the judgment. All these issues. And he makes reference also to the audit report, which is document Z, which obviously these document Z is telling because it goes into greater detail about the shortcomings of the respondent. So I will submit that the London magistrate did go through all these specific issues and did make a proper finding of fact at the end of the day. And for him, there was absolutely no doubt in his mind that there was a gross misconduct and that it was perfectly justifiable to put an end to his contract of employment.
I think you also led evidence from Mr. Toju to the effect that the plaintiff had confirmed to him during the inquiries the taking of the plants and the wood.
Yes. The last issue, my lords, if I may, is ground 3.
Sorry, just on this, page 234.
234, yes?
Yes, the second last paragraph. The judge seems to be recording exculpatory answers given by the plaintiff. for instance, that the wooden flooring was a gift following a clearing out.
Yes.
So where does he find, where does he reject those explanations and find that actually that was misconduct?
At the end of the day, when he starts the analysis at page 236,
Yes.
and I would say that at a certain stage he pauses to go through what the law says, the burden at page 238, middle of the page, line 17. The burden lies on the employer to establish that the dismissal of his employee is justified in that the acts and doings of his employee amount to misconduct, and that the misconduct is such that he cannot, in good faith, take any other course of action. And then he goes on to say at bottom of page 239, Malone, it has been established that the audit process was a continuous one with a view to determine whether serious irregularities have been committed to the prejudice of the defendant, and that same was not targeted only towards the plaintiff. It has been demonstrated from documents W to Y that several officers were being questioned, including the plaintiff, who conceded that the said exercise continued even after he left the defendant's employment. Under cross-examination, when he was questioned on the allegation he was faced with, plaintiff admitted that indeed there were certain manquements and that he was even prepared to pay for some items which are accepted. He took from the hotel, namely some wood flooring. He further admitted that the audit department, so my lord, this is the analysis of the learned magistrate, and also in the document, in the paragraph which follows, and he concludes by saying, I read this phrase, last line, the defendant was therefore entitled, and so on. So I think that's. This is the page, in fact, 240, where the two issues, that is the time, when was the date, the dismissal, and the reasons, the wrongdoings, concluding.
And this seems to be directed to a different point about when the company became aware of the facts constituting the misconduct.
This is the date, 15th of March or 5th of July.
No, I think you're confusing two issues with respect, or maybe I've confused them. The point about the 15th of March, whether he was dismissed, I understood he was saying that that was why he didn't go to the disciplinary hearing.
Yes.
The point about the timing of when they first knew about the misconduct was that they have 10 days, according to the statute, in order to notify him of the misconduct which they've uncovered. Now, those are two different points, I think.
And this part of the judgment, help us, this part of the judgment seems to be directed to a contention by the respondent that the company was aware of facts said to constitute the misconduct on 10th of May or before. If that was right as a contention, then there would have been a breach of section 38(2)(a)(3).
No doubt.
That's the argument.
No doubt. What we say is that the audit was completed on the 10th. And this is what the learned magistrate agreed. Audit terminated on the 10th. The report was submitted to the company on the 28th. So for me, it would be...
No, certainly, that I understand, but I'm just trying to understand what issue the magistrate is dealing with at this part in his judgment.
Yes.
And he seems to be addressing, well, one can debate it, not so much whether the underlying facts of misconduct have been established and made out, but a different point as to when the company became aware sufficient that they should have given notice.
Yes.
So I've understood that correctly. Right. So where does the judge find in terms that the respondent has in fact committed the misconduct, the underlying misconduct?
At the end of the day, this would be the last paragraph. The defendant was therefore entitled to find that the charges laid against him in document K1 dated have been established and that such acts do constitute acts of gross misconduct. This is his concluding remark.
I see. Yes, thank you.
But there's no particular place where he says, although Mr. Lafresière says he was given this wood as a gift because it was spare, I don't believe that. I think he took it and hasn't paid for it. There's nothing actually in the judgment that says that. It's all, you say, all bound up in this final paragraph that says they were entitled to dismiss him.
If I may say, milady, I just went through it. He mentions manquement, that is shortcomings in the judgment, and he mentions the fact that he was even prepared to pay, but he did not pay. I would think that if somebody takes, an employee takes something, and he says, okay, I will pay you, he should not have taken from the employer, and says, I'm going to pay, it is an acknowledgement of wrong. As far as I'm concerned, if you take something from your employer...
So you didn't have to resolve the differences, because even on the plaintiff's own evidence, it amounted manifestly to gross misconduct.
Yes, certainly.
I don't think, at least so far as the cross-examination is concerned, he doesn't give an explanation of some sort of clear-out.
In chief?
He simply says to you that he didn't, je n'ai pas pris, j'ai été donné, and you ask him who gave you it, and he just repeats, j'ai été donné.
Yes, yes. And then he says he's going to repay.
Yeah.
And he says, to be fair, it is common practice, but it is not ethical. It is common practice, he says so.
But yes, he's asked that about the, I think it's the plants, isn't it? He says c'est pas correct, mais c'est courant.
Oui, oui, common practice.
Pratique courant.
Yes. May I go to ground 3 in 2 minutes?
Yes, thank you.
It will take me 2 minutes. It is ground 3, 61, page 616, I think. Yes, the ground reads as follows, 616. Because the learned judges were utterly wrong in stating that it ought to have been averred in the appellant's plea that the charges against the respondent were proved before the disciplinary committee. I think this is totally erroneous. This is to be found at page 417 of the brief, line 20. I read, to be noted that in the plea of the respondent, that is the appellant now, there is no mention of the charges having been proved, and because of this it was dismissed. I do think that if we go through the judgment of SMEG, it is a judgment before the board, it is at page 776 to 786, but at page 784, I'm just going to read this paragraph. The aim of the top of the page, 784, the aim of a disciplinary committee, as we have said, is merely to afford the employee an opportunity to give his version of the facts before a decision relating to his future employment is reached by his employer. It is no substitute for a court of law, nor has it got its attributes. Furthermore, the employer is not bound by the recommendations of the disciplinary committee and is free to reach his own decision in relation to the future employment of his employee, subject to the sanction of the industrial court. So there is no onus or requirement on the employer to say in the termination letter that whatever has been proved. But we have done so. I would say that the document B is quite detailed, and that it says that the report has been forwarded, that the charges have been found proved, and that it constitutes gross misconduct, and that we have no other alternative. So I think that...
Do you accept, though, that the task of the Magistrates' Court is not simply to look at whether the disciplinary committee acted reasonably in finding it? It's supposed to arrive at its own...
Of course.
Looking at the matter afresh.
Of course. I would say that the magistrate cannot be a rubber stamp. Cannot be.
And what is there any law as to what standard of proof the Magistrates' Court is supposed to apply?
It is a case on the balance of...
The balance of probability.
That would be my submission, my lords, unless you...
I don't think there are any questions at the moment. Thank you very much, Mr. Sauzier. Mr. Duval.
Thank you, my lord. My lady, my lords, I pray for indulgence, as I must start by stating the obvious and by highlighting the depth of disagreement between the parties when it came to identifying the issues of this appeal. In our written case, we are focused on the issues we identified and responded to the appellant's written submissions relating to the 2 grounds of appeal upheld by the Supreme Court. Before I deal briefly with 4 aspects of my learned friend's oral case, it will be useful to consider how the appellant's challenge of the Supreme Court judgment has mutated over time. And for that purpose, I will refer to 3 documents. The first one is the notice of appeal, in particular the appellant's grounds of appeal at page 616, and the issues in this appeal at page 614. Secondly, I will refer to the statement of agreed facts and issues as from page 632. And I pause here simply to note that the appellant added an additional issue, and that is paragraph 36, Roman 1. And thirdly and finally, I will refer to the appellant's written case at page 641. I shall restrict myself to 5 main observations. The first observation is that it is very difficult to reconcile the appellant's first ground of appeal at page 616, paragraph 28, Roman 1, that the judges completely failed to address the issue which had to be decided as per the respondent's evidence in court, with the suggestion that this Honourable Board should determine whether the judges were wrong to have disturbed the finding of facts of the Industrial Court. That is paragraph 36, Roman 1, at page 632. It is even more difficult to reconcile the first ground of appeal with the complaint that the Supreme Court was wrong to conclude, I quote, that the respondent had been officially informed that he had no future with the appellant, unquote, or that the respondent had completed his handing over before taking another employment. That suggestion is made at page 633, at paragraph 36, Roman 3a. The second observation is that the lines become even more blurred when one considers that the appellant also submits that the Supreme Court must be understood as having endorsed all the findings of facts of the industrial court simply because of the use of the word erudite. That is at page 647, paragraph 11. Now, I pause here to humbly suggest that because of the way the case has progressed through the courts below, this Honourable Board need not be concerned with the findings of fact of the learned magistrate, or with most, for that matter, of the issues which arose before the Supreme Court. Having heard my learned friend this morning, I am comforted in my view that nothing in this appeal turns on the findings of fact of the learned magistrate. And this is so only because the Supreme Court determined the appeal exclusively on matters of law, namely those raised in grounds 2 and grounds 4 of the respondent grounds of appeal, which are to be found at page 298. My third observation is that the pleadings of the appellant speak for themselves, and there is no controversy about its failure to aver that the charges against the respondent were proved before the disciplinary committee, or that the respondent was dismissed because of his gross misconduct. It is in that connection apposite to revisit the appellant's third ground of appeal at page 616, paragraph 28(3).
Why? Can I ask first of all?
Yes.
What's the? You say the appellant failed to aver that the defendant was dismissed for gross misconduct. What's the legal significance of dismissal for? Is there any necessity in law for a person's dismissal to be on the grounds of gross misconduct, specifically?
Our law provides for protection against termination of employment.
Yes, we've looked at section 38.
38.
And we don't find any reference to gross misconduct in it.
In fact, the reference is to misconduct.
Yeah.
And in the case of Total, that my friend has cited, this board has explained how French jurisprudence has somehow colored the provisions of our law by making a distinction between faute in French and faute grave.
Yeah.
The faute grave being misconduct, being of such a nature that it would leave the employer with no other option but to terminate.
Yes, and that's a statutory test in 38 to Roman 1.
Yes.
Yep.
But I would like
That is the faute grave test,
the faute grave test. But I would
And
like
on that turns the entitlement to severance pay, is that right?
Yes. I would like to maybe turn to a very useful summary of our law provided by Lord Wilson. I say it's useful because I won the day in that case. Obviously, I'm not perfectly impartial, but Lord Wilson makes it very clear that there are two findings to be made. One, that there has been misconduct, and secondly, that the employer had no other alternative than to dismiss. But where I do not agree with my learned friend, where he suggests that the issue of good faith is intrinsically linked with that of misconduct. I say so, and I think it's better if I take your lordships and my lady to the actual provisions of the law, you will find them at page 693 is section 38(2). So 38(2)A relates to dismissal for reasons relating to misconduct. And we say that 2A1 is a substantive requirement, the requirement of good faith. And that is for misconduct. But if we turn to page 695 and to subclause 38(3), we are now dealing with performance, poor performance. Yeah. And we have the same requirement of good faith. So it is not quite correct to say that it suffices that a party avers that it cannot dismiss an employee in good faith, that it is automatically an issue of misconduct. And if I am on that subject, may I say that, with all due respect, that the question was not whether the parties had been mistaken, that this was a case of misconduct. The issue was that they had specifically pleaded that he had not turned up at the disciplinary committee and had therefore refused to submit himself to the disciplinary process. This is itself, can in itself be an act of misconduct, because it can be seen as an act of defiance, not turning up to your DC. And your ladyship and your lordship would appreciate that the case for the respondent from day one has been that it was not open to the appellant to try to persuade the industrial court that the dismissal was justified for any other reason than that submitted as per document B. That was the case, which was accepted by the Supreme Court on the basis of lateral holdings. I'm going to go back to that in a minute. And if I may also, before I move on to answer the question, is if I may turn to...
If you're right, the whole hearing was a waste of time in front of the magistrate, because in their pleading, you say they didn't try to justify the letter.
Yes. And
unless they justified the letter, they couldn't succeed, and therefore no point having hearing at all. Why didn't you just apply to say, well, they haven't alleged, just give me judgment? There's no point having all the evidence about the plants and so forth.
And I understand your lordship as saying, why did I object to any evidence which was not in line with the pleadings? I believe that the manner in which the case was conducted, is that the primary case of the plaintiff, his primary case, was that I was told on the 15th of March that I have no future in this company. And then, since the 15th of March, I have been trying to know what are the terms on which I must depart. How much time do I have to find an alternative employment? What will be my compensation? This was his interrogations. And then on the 30th of May, there is a letter asking him for written explanations. So before the oral hearing, there was a request for written explanation. And I pause here to say this. Under our law, there is no mandatory requirement that the opportunity to answer charges must take the form of an oral hearing. It is a decision of management as to whether to afford to an employee who is charged with misconduct an oral hearing. So this employer, and we see that in the minutes of a corporate governance committee, decided that the opportunity to answer the charge will take the form of written explanations. And it is then that you will see, my lady and my lords, that intervenes the legal advisor of the respondent.
Sorry, you seem to be straying a bit far away now from the point I was asking you about, which was, I mean, was the pleading point that you taken at the trial at all, or was it something you came up with in the Court of Appeal that
no, the pleading
on everything at the trial?
If I may take your lordships to the written submissions at the end of a trial before the industrial court, the difference between the plea and the termination letter was taken as a submission in law. So if I so it's before the Andrews Court, plaintiff's written submission, page 207. And you will see, my lord, at page 212, there is a whole paragraph entitled, "The reason put forward in the letter of termination versus the plea on record." And to answer your question, my lord, more directly, is that in our law, the onus is on the defendant to prove that termination is justified. So although the plaintiff has carriage of proceedings, it is for the defendant to satisfy the court of the circumstances of termination. So I didn't feel it was correct to object to the case that the defendant wanted to make before the industrial court, the more so that I took comfort that the case pleaded was not aligned with the termination letter. And that is the point I made throughout the courts below. So and that is what I wish to add. The issue was not whether there was a confusion about what the case of a defendant was. The defendant had a statutory obligation to state the reason for dismissal, and it did that in document B. And clearly, document B says, in your absence, the charges were found proved by the committee. And we, management, consider that those charges amount to gross misconduct, leaving us with no alternative but to dismiss. That was the reason given, pursuant to section 37(2). But then in the plea, the reason given was you did not come to the DC. So it is not that I felt at the time, my lord, that it was not open to them to prove the case that they had announced in their termination letter, or that it was not open for them to put the case that they had pleaded. My point that those two cases could not be reconciled. And because of that, the magistrate was bound to find that they had not justified the termination for the reasons evoked in the termination letter.
But I mean, why didn't you raise that at the start of the hearing before the magistrate? If the answer was going to be so clear, as you say it was, why didn't you say to the magistrate at the start of the hearing, look at the document B, look at their pleaded case, the two can't be reconciled.
My Lord, we do not have a practice of having opening speeches in civil cases before the industrial court or in any jurisdiction.
So it starts with the evidence, does it?
It starts straight with the evidence. And your Lordships will appreciate that document B was produced by us before the industrial court. It was the plaintiff who produced document B.
But, sorry, I didn't quite understand a point that you made a little moment ago.
Yes.
You said that they could prove the case that they had announced in letter B, or they could put the case that they had pleaded, but the two were inconsistent. So do you accept now that despite what they pleaded, it was open to them at the hearing before the magistrate to revert to the reasons in document B and say there was gross misconduct and here is the evidence for it?
I believe that, and that is one of the reasons why I did not object, my lady, I believe that if I had raised a point, it was still open for them to amend their pleadings. Because in order to prove before the industrial court that the reason evoked in document B were valid reasons, they would have had to amend. And under our law, amendments, or whether or not they are allowed, depends on the judge hearing the case, the magistrate hearing the case. And the test is very flexible one. It's whether or not injustice will be caused. So I did not feel that by objecting, I would be doing my client any service. I would have been given the chance to make good their mistake, and then I would not be standing in front of you trying to defend a judgment of the Supreme Court, which I feel is perfectly right.
So if you had raised the point, they would have said, well, everyone's come to court knowing that actually what we're talking about is the wooden floor and the plants, and they might then have been enabled to, or permitted to amend their defence.
If I may, on this point, mildly say this, and I will readily admit that my client did not do very well in cross-examination, and that's due to my friend undeniable talent. But the fact of the matter is this, that plants were taken, that wood planks were taken, was never in dispute. He readily admitted those. But the question was, these acts constitute gross misconduct. That was the question which the magistrate ought to have asked himself. And he had to make a finding whether or not the appellant had explained away his actions. And in that context, of course, my friend is right to say that an answer along the lines, c'est pas correct, mais c'est courant, is not acceptable to an employer. But it is very relevant to the issue of good faith. If it is indeed the current practice, if it is indeed courant, can the employer say that he has no other alternative but to good faith to punish that shortcomings with gross misconduct, with terminal? And in that aspect, two issues are important. It was not only the plaintiff who had admitted to shortcomings. 3 other officers had admitted to shortcomings. They had given their written explanations and they were given warnings. But most important, what is the accusation
They were
against the
not
plaintiff?
dismissed, you mean? They were just given warnings?
They were just given warning. So there was another alternative than dismissal for these people. But what is the most glaring evidence And my learned friend was careful not to mention that name, and I understand why. And that is Mr. Jean-Marc Lagesse. He is at the center of this case. The audit, which started in January, my lady, my lords, did not target the plaintiff, the respondent today. The audit was targeting Mr. Jean-Marc Lagesse, the former general manager of the two hotels of which the plaintiff, the respondent, was responsible for the maintenance. And in fact, it is not disputed, but after the audit had started, a deal was reached with Mr. Lagesse, one which made a lot of noise in Mauritius, one which was the subject of many press articles, and that is on the record. And the point that was being made is that the charge of gross misconduct was that you have helped Mr. Lagesse circumvent internal procedures. So clearly, and we see in document K1, that 4 of the 5 charges mentions either Mr. Lagesse in person or La Cage Chamarel, which is a property of Mr. Lagesse. And when we look at the document of the 30th of May, we see that there are terms like conspiracy to defraud the company. But who is the main beneficiary of those shortcomings? Alleged shortcomings, Mr. Jean-Marc Lagesse. And when it comes to Mr. Jean-Marc Lagesse, it's possible to make a deal, and a very generous one, as per the record. But when it comes to the respondent, there is no other alternative but to dismiss. That was the point that was trying to make. And if I may jump to another point, a lot is being said about the audit was completed on the 29th of May when the report was given. Again, that was not disputed, my lady. We do not dispute that the audit ended when the report was submitted.
In fact, I think in your pleadings, you set out the document, you refer to the documentation from the charges through to the letter of dismissal, and essentially you say that you effectively it's treated in your pleadings as a sham because the real decision had been taken at an earlier stage. 15th of March. Yeah. And on the issue of timing, what we say is that you knew exactly in January what was the charges. Mm-hmm. You put them to us. In May, you came back and asked us the same thing over again. But most important, in between, you had made a deal with Mr. Lagesse. And what we said is that management cannot be believed when it says we knew nothing about the audit results, because we could not level charges until we had the report. And that is where we disagreed. That is where we referred to good faith. And we said, if you were able to make a deal with Mr. Lagesse, surely as a listed company, you would not have made such a deal until and unless you had some idea of what that audit was revealing.
But you lost on this point.
Yes. Before the industrial court, I lost on all points. Before the industrial court, what the magistrate merely said, you did not turn up. You were wrong to consider that you have been dismissed. You did not turn up. Your employer was entitled to find the charges proof. And they were entitled to find that those charges amounted to gross misconduct. So he basically said what our laws, our court, constantly said you should not do. Our law is clear. It is for the court to make a finding that facts constituting gross misconduct has been proved. It is for the court to make a finding that those facts actually constitute gross misconduct. It is for the court to make a finding that, in view of the misconduct proof, the employer had no other alternative to dismiss. And that magistrate made none of these findings. He merely said, in fact, my lord, he accepted the case that was pleaded. But then, sadly, he mentioned document B in his final words. So he said, they were entitled to find the charges proved, and I'm satisfied they had no other option for reasons stated in document B.
Can we just look at that again, or which page is it?
Pardon?
Can we just look at it, what he
Yes.
said again?
Page 241. That's the last sentence my friend has been referring to. I find that the defendant has established the termination of the plaintiff's employment was justified in the circumstances. That's the first part. And that it could not in good faith take any other course of action than to terminate the plaintiff's employment for reasons given in document B. So he referred to documents B for the reason for which they could not in good faith take any other course. But when it comes to the entitlement that the termination was justified, he actually, we have to turn to page 240, here's what is written, the last paragraph. The plaintiff was also given the opportunity to give his explanation before a disciplinary committee, which he chose not to attend. The defendant was therefore entitled to find the charges laid against him in document K1 dated 6 June 2013 have been established.
Yes.
It is clear that the magistrate does not find gross misconduct proved. He finds that because he chose not to attend the DC, his employer was entitled to find the charges proved. There's a world of difference, one which the Supreme Court identifies and criticizes.
You said earlier that on the 30th of May they wrote to him
Yes.
asking for his written explanations
Yes.
as to the charges. Did he respond to that letter?
He responded through his attorney.
Is that response in the bundle?
Yes. It's at page 255. And your ladyship will see that the response is a very polite one from the attorney, which says two things. She first states what her instructions were, and the instructions clearly were, since the 15th of March, I was told that I should look for another job. And then she asked to Mr. Piat, who is the representative of the company, before we tender final advice to our client regarding your request, we would be much obliged if you would indicate whether management is willing to enter into without prejudice negotiation to explore the possibility of a termination by mutual consent. So he never said straight away, I will not provide explanation. He said, well, his lawyer said, well, you already told him since the 15th of March that he had to look for another job. Can we talk about termination by mutual consent.
The answer to the actual charges seems to be given in the previous paragraph 1, which is saying we've already gone over all this
Yes.
in the internal audit.
Yes.
So I would read that as saying, I've already given you my answer
Yes,
to this.
and I believe my friend
But it
does
says
not...
somewhere in the internal audit that we see what his answer to the charges.
But auditor's report does state that he gave his explanation. In fact, you will... you would see at page 290, under maintenance 290, first on the top, third full paragraph, the internal audit through the hotel's human resource manager requested clarifications from the maintenance manager, that is the respondent, on the above matter. Explanation received from the maintenance manager was that instruction to send garden superintendent to La Cage Chamarel came from Mr. Jean-Marc Lagesse, and that the letter also gave instruction that the garden superintendent be given days off. And then you will see that under each bullet point...
And Mr. Lagesse was his superior?
Superior, the director of the two hotels.
And what about the plants and the planks of wood?
So you will see that I believe the plants were not at the end. Plants taken from the Saline, page 293. That's the same charge, the plant. So in that issue, you will see, my Lord, that the plants had to be built was not really the question. The question was what was the price at which the plant had to be built. So if we look to page 294, after the second table, the price of 50 per plant was applied in the initial billing made to La Cage Chamarel, was upon instruction given by the maintenance manager on 3rd December for an email. Based thereon, the internal audit wishes to draw attention to the following, and then there is the explanations. So to answer...
Yes, 295, he deals with the planks.
Yes. And to answer my lady on whether he provided explanation, I don't think that it is, but in fact it was put to him that he fully participated in the audit. So it is not that he refused to give explanation. It's when he was asked for written explanations, his lawyer intervened and requested to be told whether there was any hope of a settlement for termination by mutual consent. May I move on to my third observation? So the third observation concerns the pleading. And it was being observed that the pleadings of the appellant speak for themselves and that the averments were simply not made. And I was referring to page 616, which is the actual ground of appeal, and it reads as follows. Because the learned judge were utterly wrong in stating that it ought to have been averred in the appellant's plea that the charges against the respondent were proved before the disciplinary committee. Now, I understand the written case to be slightly different, and that the suggestion is that what had to be pleaded had been pleaded, and that in fact one ought to read, I quote, could not in good faith take any other action than to dismiss, as meaning he was found guilty of misconduct, which left us with no other option. I obviously disagree with the proposition that the mere mention that a employer cannot in good faith take any other action than to dispense with one's employee cannot necessarily mean that gross misconduct has been proven. It could very well be that it was a matter of performance.
But could there be any doubt about that in the context of this case, in the light of everything that had flowed under the bridge?
There was no doubt, my lord, that the employer considered or had announced that it had dismissed the employee because it considered that the charges had been proved. Now, I stop here to say that the requirement of our law is to state the reason why you are terminating. I do not believe that just to say you are terminated for misconduct is to state the reason. You will note, my lord, that document B does not even make mention of a charge letter. It merely says all the charges that you have to answer have been proved.
Sorry, which letter were you just referring to?
That is document B.
Page 245.
Yes.
So if in my written case, my lord, I attempted to analyze that document in detail, and if I may repeat, the document is divided in two parts as far as I read it. The first part is the introduction, mainly only says, you were convened and you did not come. But then it also says, you failed to turn up and to provide any reason for management as regards such failure. Clearly that is not accurate. Clearly the employee, the respondent, had made it clear why he was not coming. So that to start with, although the magistrate accepts document B in toto, clearly a statement in document B is not accurate. It is inaccurate to say that the respondent did not give any reason for failing to attend the DC. He explained that he had considered that he had already been dismissed. He explained that he was legally advised that he had already been dismissed. Then he is told the DC took place in your absence, which is perfectly normal to do. And then the operative part of the letter, I submit, starts with the phrase, this served to inform you that management. This is the requirement of the law, informing him of the reason of his termination. And here we see that free subparagraph, Roman 1, the chairman has made a report. In the light of the evidence before the committee, the charges were proved. Now, what we understand by the charges are proved is that the facts stated in the charge have been established. In a little parenthèse, the facts were not disputed. And then we have 2, management has accepted the report and it considers your acts and doings are tantamount to gross misconduct. That is the view of the management, not of the discipline committee. 3 takes the view that it cannot have in regard to the above. So for me, the above is Roman 1 and Roman 2. Take any other course than to dismiss you. So clearly document B is about gross misconduct on the basis of charges found proved by the DC. But in document B, there's no mention of what charge that is. There is not even a mention of document K1, which is the charge letter. So,
But with respect, are the charges not those which had been levelled and spelled out in the documents to which we've been referred during the course of this hearing?
pardon, yes, the charge are in document K1.
Yes.
But the charge, if we look at document K1, we have different reproaches made. And one, as I say, it was not in fact a matter of controversy.
So I think this is page 258, is that right?
Yes. 258 is K1, and you will see that this is the charges level for the purposes of the oral hearing. There is an earlier letter.
But just pausing on that.
Yes.
The document B seems to say all these charges are treated
All
as
the charges that you had to answer.
Right.
There was another opportunity where he was given to answer. That's document H. 30th of May 2013, page 252.
Yes, but we've got past that now. We're looking at what it was that document B is referring to when it says the charges heard by the disciplinary committee.
My point is that it's not clear, my lady. It could be document H, it could be document K1. All the charges you had to answer.
But with respect, was there ever any doubt about that?
Honestly, my lord, there is no doubt in our law that in order to convene someone to an oral hearing, you must set out the charges.
But the chronology of the correspondence,
Yes?
beginning with the letter of the 6th of June and giving notice of the date set for the disciplinary hearing, as a complete whole, points to the charges being those set out in the letter of the 6th of June, does it?
Yes, I have no issue that the employee was convened to an oral hearing to answer charges in K1. What I am humbly suggesting is that the requirement of the law is to be given the reason why you are terminated. And it does not suffice, in my humble submission, just to say all your charges that you had to answer had been proved.
But why isn't that enough?
Because then,
I mean, this isn't a ground that the Court of Appeal, the Supreme Court decided in your favour, is it?
also in United Docs.
But you're not, I mean, we're concerned with what the Supreme Court decided and whether it was right or wrong.
Yes.
You're now seeking to introduce a new argument, which is not part of what they decided, and I can't see how it comes into this appeal.
Yeah. In my humble submission, and that is why I said there was a profound disagreement as to the issues arising from this appeal. The Supreme Court held that it was not open to an employer to seek to prove before the industrial court justification other than those stated in document B. That is the first point. The second point that the court held was that the magistrate did not make a finding that misconduct was proved before him. All he did was to say the employer was entitled to find charges proved. And that, under our law, is simply not good enough.
But maybe they were mistaken in that because they seem to think at page 417 that there had been no evidence adduced before the magistrate as to whether the wooden planks had been taken, whether the plants had been invoiced, whether the employees had been sent to do private work for somebody else when they were being paid by the hotel.
Yes.
But what Mr. Sauzier says is that's not correct. He came to the magistrate's court prepared to prove all those things, but as you say, once he had skillfully cross-examined your client accepted all that.
Yes.
And so the Supreme Court was mistaken if they thought that there had been no basis as a result of what happened at the hearing on which the Magistrates' Court could have found those document K charges proved. Now, what's your answer to that?
I understand what the Supreme Court is saying. He did not make a finding that the charges was proved in front of him. He only found that the employer was entitled to find the charges proved because the respondent did not turn up. I readily concede that the Supreme Court did not get it quite right when it said there was no, or what my friend considered that way. Let me make that very clear. What the Supreme Court says, it does not say that there is no evidence. It refers to a concession from my learned friend. And I will concede that my friend never made such a concession in so many words. But what the Supreme Court also says, and it at page 148, from line 7, the manner in which the defense of the employer was pleaded led to an obfuscation of the real issues which needed to be established and decided upon. This was followed by addressing many factual issues to be dealt with during the lengthy trial. And we go back to the pleadings. According to the pleadings, the reason for dismissal was that you did not submit yourself to disciplinary proceedings. The case as pleaded and by which the appellant was bound was at paragraph 16 of its plea.
Well, that's the point you made, but that, it is said against you, is a very formal point. And it may be a good point, but it's a very formal point, bearing in mind that there was never any doubt as to the issues.
I do concede that is a formal point. That is the state of our law. As per the case of lateral holdings, it is simply not open to an employer to invoke before the industrial court reasons other than that stated in the termination letter.
No, in the pleading, I think, is your point.
Pardon?
In the pleading,
yes.
If they can get to the termination letter, then I think you're almost accepting that it's not looking good for your client. But I thought the point you were making was that, technical or not, there is a point that they hadn't pleaded
misconduct,
yes,
and that you say, maybe as a result of that, or for whatever other reason, the magistrate court addressed the wrong issue, which was not, have I, as the magistrate, been satisfied that there was this misconduct and it was gross misconduct, but simply, was the disciplinary hearing entitled to come to that view, which would be the wrong question. And I think Mr. Souzier accepts that that would be the wrong question.
Yes. If I may, my lady, come back to the finding of the Supreme Court. What the Supreme Court found was that the magistrate did not appreciate that the appellant had not pleaded document B. So there is two separate issues. There is a general principle about pleadings and how both a party and a magistrate are bound by pleadings. In fact, I had referred to the case in my submission to the motion decision.
Just before we return to it, I mean, has her ladyship not put her finger on the crucial question? Your argument is that the magistrate misunderstood his function. He decided the case on the basis that the employer was entitled to dismiss, rather than himself deciding whether the circumstances justified dismissal. Now, and you point to the way in which the sentence at the foot of page 240 and the top of 241 is expressed. Now, we're dealing with, as against that, it might be said against you, that the magistrate is a specialist. This is an industrial court. So he's an expert in this particular area of the law and presumably dealing with it all the time. And when one sees what he says on page 238, he reminds himself of he starts at 237, but the main passage is 238, reminding himself of what the relevant legal principles are. And in line 16, he writes that the burden lies on the employer to establish that the dismissal of his employee is justified in that the acts and doings of his employee amount to misconduct, and that the misconduct is such that he cannot in good faith take any other course of action than to terminate his employment. Now, what's really implicit in your argument, I think, is that by the time he got to page 240, he had forgotten or overlooked that.
I think the Supreme Court says that. There was an erudite approach, but sadly, he got lost in the way because he never made the finding. And in fact, I think my learned friends have relied on the decision of Bissonnette, which is at page 704, and at page 708, we see what is the approach of the court. The approach of the courts at the top of the page, 708, the approach of the courts in Mauritius, in contrast to the approach of the United Kingdom courts, would be to substitute their own view for that of the employer, rather than simply considering whether the employer's view was a correct one. And that is what the Supreme Court says. He failed to find the charges proved before him. And if I may also turn to the case of United Docks, which I think is also a very relevant statement of principle, at page 834, paragraph 24. A question whether the company had a valid reason to dismiss the respondent is obviously different from a question whether it could in good faith take any other course than to dismiss him. The former asked only whether misconduct was a ground for dismissing him. The latter asked whether in all the surrounding circumstances, the only reason open to the employer was to dismiss him. In other words, was it, as the board in paragraph 17 of its judgment in Bissonnette versus Sugar Fund Insurance Bond, the only option? So the learned magistrate had two findings to make. He had to find that misconduct was proved before him. He did not. And he also had to find that in all the circumstances, the employer had no other option. He also did not make that finding. And that is why, in my humble submission, the criticism of the Supreme Court are perfectly justified. And by reference to this criticism alone, the appeal before the Supreme Court was rightly upheld, and this appeal should be dismissed.
Can you help me with this? In his judgment on page 240, line 4 onwards, the magistrate records what was said by the plaintiff under cross-examination.
Yes.
And records his admission that there were indeed manquements, failings, or I suppose on shade of meaning, it might be failings or it might be shortfalls, and that he was even prepared to pay for items which he accepted he took from the hotel. Why record this if what you're concerned with is the not your own view of what's been proved in front of you, but rather what material was before the employer at the time when it took its decision?
Because we have another requirement in our law, my lord, is that what the magistrate must find is that the evidence which was available to the employer at the time it took the decision was sufficient.
Yes,
So it's
well,
not just...
well, that's why I'm asking you the question, because this passage in his judgment isn't concerned with the evidence before the employer. It's talking about the evidence before him.
Yes.
Bearing on whether there had been misconduct.
I believe the way in which the judgment is written indicates, if I may say so, that the magistrate first sets out what is the case of the different parties. He goes in detail, he recites, recaps, summarizes the evidence, which he then starts analyzing at page 236. But as Lord Sales correctly pointed out, the analysis is directed to one point: the time at which the employer became aware of the misconduct, of the facts constituting misconduct. So his analysis, the whole of it, is directed to one point. He never analyzes the evidence for the purpose of finding whether or not charges of misconduct have been proved.
So is this the legal position, that although it is for the magistrate to arrive at his or her fresh determination as to whether misconduct has been proved, whether it's serious, etc., they can only base that on material that was in existence at the time of the dismissal?
Absolutely.
Not subsequent?
Absolutely.
Right.
And that is, I think, a very settled principle of our law.
Can I just ask you this about the passage in the final paragraph on 240, which we've been focusing?
Yes.
You've said that the magistrate had to find first whether misconduct was proved, and second whether there was no other option.
Alternative, yeah.
So on the first, I understand your point on the language used entitled defines the charges against him. Mm-hmm. But if one reads that as the magistrate himself agreeing with the view formed by the defendant, wouldn't the next sentence, I found that the defendant has established the termination of the plaintiff's employment was justified in the circumstances, and that it could not in good faith take any other course of action, sufficiently address the second of the matters that you've said the magistrate had to address?
I will humbly submit that no, because when it comes to the second issue, if I may just, before my Lord, just one clarification. To come out, to make a finding as for the first part, it does not suffice to say the facts set out in the charges have been established. Those facts must constitute gross misconduct. And in a case like this, there cannot be gross misconduct unless there's an intent. So it might seem laughable to say, c'est pas correct, mais c'est pratique courante. But it does address a very important thing. I did nothing wrong by the standard of our company. This is a pratique courante. If that is accepted, then there cannot be misconduct. But the thing is that the magistrate doesn't even consider that. That's the first point. The second point is by saying that I am satisfied that they could not take any other course for reasons given in document B. My point here, my Lord, is that document B clearly says, in the light of the above, we have no other alternative but to dismiss you. And in the light of the above is Roman 1 and Roman 2. Charges prove, we consider them to be misconduct. But the nature of the misconduct cannot be the only relevant consideration when, in this case, the plaintiff was not the only one concerned with the audit. There was Mr. Lageste, a deal was found with him, there was 3 other officers which were given warnings. So how could the magistrate come to a conclusion as to whether there was no other option without considering these other considerations.
Was Mr. Piat cross-examined about the...
Yes.
Right.
And I was actually asking. In fact, Mr. Piat was cross-examined on the deal with Mr. Lagesse. And the question put to him, but that he did not do very well either, Mr. Platt, like my client, was that how could you, being a listed company, how could you have paid over 40 million to Mr. Lagesse without having any indication of what the audit was revealing? That was the question put to him. How can you say to the court that you had no idea, that you knew nothing about the audit until the 20th of May, when the main person targeted by the audit walks off with 14 million in the sunset?
And sorry, bundle reference?
This is all very interesting, but evidently this appeal isn't about whether there was an unfair picking on Michel Lafresière while others walked off with their pockets stuffed with gold.
But it is a fact, my lord, that he did not make a finding whether it was the only option. Because if he had addressed his mind to whether it was the only option, he would have been bound to consider these things. But I agree, the Supreme Court did not decide this case on this factor.
No. Well, I see the time, Monsieur Duval. I think we had better adjourn now, and we'll resume at 2 o'clock. And I hope you'll be able to complete your submissions quite briefly.
Can I just ask a question that you might want to discuss? The word manquement there, which has not been translated, does it have a flavour of seriousness or not seriousness? Is it, if it's referred to as a manquement, does that mean it's not anything terribly serious, or does it mean it is, or perhaps it doesn't have any such connotation? It might be useful if you could.
Yes, we can return to that at 2 o'clock. Thank you.